The next Chief Justice was the great Chief Justice, as he's still referred to, John Marshall. He served from 1801 until 1836, 35 years as Chief Justice. He wasn't John Adams's first choice. He wanted to Adams wanted to reappoint Jay, but Jay, of course, declined, saying that the court, quote, lacked energy, weight, and dignity. It's probably a fair assessment. Later on, John Adams referred to his appointment of Chief Justice Marshall as, quote, the greatest act of my life. Marshall enormously expanded the influence of the court and of the federal government because he came with a Federalist, was appointed by a Federalist president, and was of the view that we needed a very strong national government. And so decisions that arose concerning the powers of the national government were almost invariably decided in favor of the national government. But he did something more, something that stays with us every day today.
In 1803, the Supreme Court decided a case, Marbury versus Madison. It may be the most important case it would ever decide. This is what the court said. An act of the legislature repugnant to the Constitution is void. And, lest there be any doubt, the court added, it is emphatically the province and duty of the judicial department to say what the law is. With these few lines, the court established the principles that any government action inconsistent with the Constitution is void, and that the courts will decide what is and is not consistent with the Constitution. That's called judicial review, and that's what happens whenever Americans go to court to assert or protect their constitutional rights.
Judicial review was not something that came with our heritage from British law. There was only one instance recorded in British law where a court declared an act of Parliament void, and that was 200 years earlier. It was a practice that arose under the Articles of Confederation in many of the states, but it was regarded as logically implicit in having a written constitution. Marshall went on in Marbury versus Madison to say, the powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written.